Okay, if the court reporter is ready and the witnesses are ready and the panel is ready, I think we'll resume. I think there was a document that was provided to our counsel that was talked about earlier in the hearing, so why don't we go ahead and put that into the record.
Yeah, just preliminarily here, during the break, MetLife has provided us with a document entitled Death Match Referral to Life Insurance or Total Control Accounts. I want to ask the court reporter to receive a copy of this from MetLife. Has that been provided to the court reporter?
It is not, but it will be provided for the conclusion of the hearing.
Okay, and then I would like the court reporter to mark that as Exhibit 1. And just so we're very, very clear on this, would one of the sworn witnesses please testify in just a few sentences as to what this document is? It's dated September 8th, 2010.
Sure, I'll take that question. As I mentioned earlier in the morning, we do have and have had a process, my understanding, to share information with other parts of the company, in particular on this document with our life insurance death claim unit and our total control account unit. That process was informal, and then we began to formalize that process in early 2010, the first part of 2010. This version that you see here is the latest version of the current process that we use, and I can answer any other questions you might have at this point.
Okay, and just so I'm clear, this is a 2-page document. Is this the totality of the document, or is there more to this document?
I'm not sure I have the answer to that question. I've been told that it is the entirety.
Okay, thank you. So before the close of this hearing, if you'll make sure to get a copy to the court reporter for marking, we'd appreciate it.
All right, and I believe there were some other questions we had in the first half of the hearing that MetLife wanted a chance to do a little more research on, and I think we might have an opportunity to hear some testimony about some of that at this moment.
And I'm going to give the data quickly. There's only a couple pieces, and then certainly you could ask more follow-ups. Toward the end of the testimony, there was a discussion of lost addresses, and in particular, or bad addresses, and our procedures around that. I wanted to give a couple of clarifying statements. First of all, if in fact we get returned mail into our individual life unit and it indicates deceased, we will perform an investigation similar to the investigation I described when we get a phone call that advises us that someone is deceased. I'm not going to go through that whole investigation process again, but I can if you'd like. Secondly, in our address correction unit, we do have procedures, and I did confirm them, to use publicly available sources of data, such as Accurate and RootsWeb, to determine if there's any indication that that individual is dead. Again, that supplements those topics. Do you have questions on those, or there were a few others that you?
No, I don't think we have any additional questions on that.
Okay. So the other ones are very quickly. They are dates that you had asked for about when we began using Death Index or Death Master in various businesses. And I'm going to give you some dates. I would say these are approximates, only because I got them from someone else I want to validate, but I'm sure that the order of magnitude is close. And what I'm describing here is for our disability business and for our long-term care business, and I'm describing usage for individuals that are in claim payment status. So for individual disability, we began using the death match in 1995. I was not able to ascertain the frequency of that or any decisions that led to its usage. And in 2001, we began using it for group disability and for long-term care. So I believe we testified a little bit to frequencies on these already in the current state. So if you have further questions, I'd be happy to answer them.
No, I don't think we have any additional questions on
Okay, so that was really all of the follow-ups that we had.
Okay, thank you. Now I want to turn the mic over to Controller Chung, and in order to afford him an opportunity to ask a series of questions.
Thank you. Please describe the organizational structure within the MetLife entity that handles the street obligations for the state of California.
Okay, so I'm going to explain a nuance that I'll need to describe. We have an unclaimed property organization that is part of my organization, which I can talk about how that works. However, each operation within the organizations has responsibilities to determine when it's appropriate for a specific item to go into the unclaimed fund system. So the way I would describe it is the admin unit that has accountability for any given business, and we've talked about the varied businesses, has responsibility to employ administrative processes to identify when something should go into the system, and then the unclaimed funds group, which is my organization, is responsible for the management of those funds from once it's put into the system through ultimate escheatment.
I'm sorry, so can you describe when you say when something goes into the system, what that something is?
Sure. So that something could be uncashed checks. It could be
So any unclaimed property, that's what you meant?
yeah, oh
something.
yeah.
Okay.
And that process can vary for the different types of property.
And so how is that determination made within each business unit?
Sure. So within each business unit, we have administrative rules that incorporate our best understanding of the appropriate regulations in any given jurisdiction, including how they may vary for any given contract. And those rules are included in the administrative procedures for each of those operating units. And I'm not purposely being vague. I'm just they do vary by area. So.
And how are the administrative rules reviewed and enforced?
So I'll answer this more broadly across our organization. We have control processes, including auditing processes, that are aimed periodically to look at our different businesses to assess whether they are operating consistent with our contracts, with our customer expectations, and with applicable law in any given entity.
You raise an interesting point. So how do you test that versus consumer expectations?
Well, consumer expectations are very important to us. So one of the things we look at very closely is the responses we get from our customers, whether it's customer complaints or surveys that we do or any feedback that we get from customers. Sometimes it's quite good too. And we certainly incorporate that in to help us understand where we have opportunities to get better.
And how long have you been doing that and the frequency by which you do that?
So I certainly can tell you in some of these businesses we've been doing customer service surveys for at least 10 plus years. It may be further than that. It varies by business in terms of who we're speaking to. I can't tell you an exact date for any given business, but it's not a new phenomenon. In terms of complaints and tracking complaints, there are statutory requirements around how you do that, and we have an organization that's accountable for making sure we manage that appropriately.
Okay, and you said it's subject to audit processes. Are these internal? And to the extent they're internal, can you describe the process by which you do internal audit reviews? And then to the extent that you do any external audit reviews, please describe who you consult or contract with.
So we have a fairly robust internal audit process. I'm probably not going to be able to give you exhaustive detail on how it works, except to say that the auditing team is essentially auditing against the controls and the expectations. Once we select a business to be audited, we'll perform the audit. They may assess findings out of that audit, and from there may be management actions that we attempt to act upon out of it, and that's internal. External auditor, certainly we have an external auditor. I'm not aware, and there may be others on the panel who are aware, if our external auditors have been involved in any of the unclaimed property audits. I don't know, Mr. Cassandra, if you are.
I don't have any knowledge of them having done that recently.
Can you share with us any of the findings that the internal audit reviews have identified over the past few years?
At this very moment, I don't have those at my fingertips. Presuming it's not privileged, I assume there's things we can share there? Yeah.
Yeah.
So, sure.
If you could go back, contact the appropriate individuals and share
Sure.
the findings as they do. My concern is this. In 2002, MetLife escheated property to the state of California, and one of the categories is annuities. A second category is death benefits. So assumed that you fulfilled your obligations on those two particular property tax codes or property type codes for 2002. But in 2003, 2004, 2005, 2006, we do not have property submitted to the state of California under those property types. And that's why I was trying to get to my earlier question that I asked, do you have some type of identification at what level of management? Because you may have lines of businesses that are fulfilling your obligations, and in other areas, you have inconsistent application, perhaps of the rules or a change in policy. So I'm trying to get a sense of what is taking place.
So would you be so kind as to repeat those dates, just so, we're not going to be able to respond to them today, but I want to make sure we have them, and then certainly that's information I'm not familiar with. We'll go back and take a look at it.
Sure. So in 2002, we received escheated property, and the categories, two that identified were annuities and death benefits. However, property escheated by MetLife in those categories, we do not appear to have any for the years 2003, 2004, 2005, and 2006.
Okay. So we will take a look at that. I mean, one possibility that I will throw out is the potential that we've got some coding issues. So coding issues in our systems.
Okay.
Because, well, so let us check that out and really make sure. Our intent obviously is to submit unclaimed property consistent with what it should be, and it's reasonable that if we had it prior, we should have had it in those years. But I want to check that out for you.
Okay. And then following up on your last statement, you do want to escheat. How does MetLife determine when it will escheat proceeds due under policies identified by its 2007 comparison?
So the actual, so we're going to talk about individual life. And for individual life, we escheat based on it's based on the time we know we have a liability that's due and unpaid, and we can't find the rightful owner of that property, then we begin the unclaimed property process, which I believe in California is 3 years. The 2007 match was somewhat unique in that we made the decision to waive the requirement of proof of death. So one could assume if we had required proof of death, then the escheatment period would have started subsequent to 2007. But instead, we chose not to require proof of death, and as such, used the 2007 date as the date for purposes of establishing liability for unclaimed property.
And so you use the term to know. Can you further delineate your definition of to know? So actual versus constructive, actual, if you choose actual or somewhere near there, what constitutes sufficiency for the policies of MetLife?
What I prefer to testify to is what we did, which was when we ran the match in 2007 and identified that we had information indicating death kicking off investigations that subsequently weren't successful, we selected that date as the date, as opposed to using a subsequent date where we would have to have proof for the purposes of establishing an achievement date.
And which unit within MetLife makes that determination?
That would have been for the purposes of the '07, and I'm not exactly sure if that was done in the claim area or the unclaimed funds area. We can certainly get you an answer to that.
And the variation in 2007, and how was that determination made and by whom?
I do not know the answer to that, but
Okay.
we can certainly let you know.
I understand that there may be perhaps some shortcomings in the 2007 approach, but I thought the 2007 approach was more constructive and ultimately resulted in a resolution to the benefit of the beneficiaries. Has there been any discussion as of the action you took in 2007, perhaps moving to that type of approach?
There has. So for the life business, as with other business, we have implemented a new comprehensive approach that began in late 2010, where no less than annually we will match the death index. And we think, as we described before, that'll provide a valuable safety net for the limited number of policies that don't come in through the normal course. We have not yet perfected all the details of exactly how that'll work in the context of what we would accept for proof or not, as we talked earlier.
That's the third time one of you has used the term safety net.
Right.
I actually don't believe it's the most constructive approach, right? It is a back-ended approach, even though you get to the point where you're trying to assist individuals. Why isn't it used more affirmatively as a tool at the front end? One of the comments was you didn't want to insert yourself into the process, but I don't personally find it invasive if, in the event that somebody passed away in my family, to receive notice that we may be the beneficiary of proceeds when a loved one passed away.
Yeah, so we're now going to have a conversation about timing, right, is really what we're talking about. So we think the normal process works quite well, and we can debate the numbers, but over the period we looked at, $44 billion paid, only 80 million found with the death index, and that's over a really long period of time.
And $44 billion describes which universe?
So for the 2007 match, the universe of policies that we matched on that same period, we paid out $44 billion through the normal process, but for the matches, paid out about 80 million.
And so your comments originally said it in the context of of life policies. We're still talking about.
That is correct.
Okay.
Yeah. So your question is a fair one. Why a year? Why not 6 months or 3 months or every month? And so we spent a fair amount of time as a group as we implemented this procedure to come up what we thought was the best answer. And what we felt is we're talking about a process around life insurance that generally is quite effective. Our data shows the vast majority of claims come in through the normal process. And we would never want to implement a process that leads beneficiaries to believe, or individual policyholders to believe, that they don't need to discuss with their beneficiaries how much life insurances they have and have that beneficiary understand their responsibilities under that program. Our presumption on that is if beneficiaries understand that, they will file claims, and generally that's what has happened. It's early days on this. We think, since we ran it in '07 and we'll run it again in '10, we'll see what kind of data we get in terms of what falls out. If we find, as we continuously perfect this process, that running it more frequently would be a benefit, we'd give that consideration. What we've said is we're going to run it no less frequently than once a year.
Do you see any disadvantage to doing it more frequently? Is there a significant cost to running this match?
We think that the concern would be that it would circumvent the standard process right now. If you think just from a practical standpoint, you could get communications that cross in the early days surrounding the death of the insured, where the company's trying to reach out, the beneficiary is either trying to reach in or is not yet prepared themselves to reach in yet. So there's the practical question of the timing of the communications between the beneficiary and the insured.
So I appreciate your concern for the loved ones of individuals who passed away. Have you done any substantive research as to the proper time for an insurance company to interject themselves in the process?
I don't know of any research on that particular aspect.
So let me go back to the original question. What's the disadvantage? Because you said you may cross over. We don't have clarity as to whether there is a negative impact to providing a letter of information to the beneficiaries. I don't understand the harm, and if there's not a cost concern, I'm not clear what the objection is.
Well, and I don't want to say whether there is or isn't a cost concern, because we haven't allowed that to be a driver in our decision-making process. I don't know what the costs are. I think the prevailing thought process here was that the current process works extremely well. And so adding something above the current process is something that we thought made sense. I think this is a great topic for dialogue between the insurance industry and regulators to talk about what best practices are, and we would be very interested in engaging in discussions. We developed this 1-year period based on the analytics coming out of our '07 match. So we have done some level of research, and we found that that is a good duration, but we'd welcome dialogue if there's a best practice to get at here and try to help get at it.
And I sincerely appreciate that, because we are trying to do the same thing, reach the best outcomes for people. I'm still not clear. So you said you did the analytics of 2007. You did the analytics measuring what exactly?
So, and I don't have the numbers in front of me, but when we looked at it from the date someone goes on the Social Security file, what's the proximity of that for death payments? I want to be careful. I don't want to testify to a process that I don't have extreme knowledge to. I'd say all the analytics that came out of the '07 match led us to believe to do it no less than frequently than 1 year was the right answer. I'd say if there's data available that indicates we have an opportunity to significantly improve the customer's experience by doing this sooner, we'd be happy to engage in that dialogue. I also think we just ran it again for the individual life business this past month, and we'll have some new learnings that come out of that we'd be happy to share. And I just want to be careful, because we're having a discussion about a process that we believe generally works quite well, and a change to it that we believe will make it work even better.
Yes. So that's the issue that's unresolved in my mind. You state it works well, but we don't have criteria, and then we don't have outcomes, right? This could be very easily resolved if they ask the question, across the base, what would be the appropriate time for us to notify you when you can apply and when you will submit your claim, the best way to submit the claim so that you can get a return of the monies, the proceeds.
Yeah, I think you're making a good point. Should we speak to our customers and understand what they want in the context of doing this? There is one thing we just have to watch, and I want to make this a point, because what I wouldn't want is anything that we do result in beneficiaries believing that they do not need to submit a claim. Because it's very possible that there'll be situations that for whatever reason someone doesn't get on the death index or gets on the death index much later. And so we want to be very careful that there's nothing that we do, or we as an industry collectively decide to do, that leads beneficiaries to believe that they don't have the responsibility to submit claims. It's an important part of the system, and it works quite well. So we've been looking at it in addition to what they do. How can we make it even better? And so I just think that's a dialogue we want to be conscious of as we think this through.
Okay, so if you don't use the actual date of death as triggering the dormancy, what definition does MetLife use, so that I have a clear understanding, so we can have a further discussion of your escheatment obligations to the state of California?
So I believe for life insurance, we use the date due and payable when we're not able to find a beneficiary.
Could you restate that again? Due and payable.
So when we believe we have a liability, when we believe we have a liability on our books to pay out proceeds, and we can't find the beneficiary to whom that money is due to, we would then kick off our unclaimed property process, starting with the date that we believe we have that liability.
So, referencing scenarios discussed earlier, an individual calls in believing that they may receive some proceeds, and then you start and I believe it's standing operating procedures, right? You mentioned how you address some of the claims. I don't know if it's routinized within MetLife. They do not submit a claim. They do not submit any information or provide a death certificate. At what point do you determine that there is a liability due?
I think it's at the time when we receive sufficient proof of death and as such approve the claim. That would be the time that we would begin the liability. And that sufficient proof of death in our standard process does involve getting a death certificate.
So,
Could I just make one point that I'm not sure is obvious to folks? There's almost, the question that's sort of sitting out there is just the fact that someone has died means that the company has a liability. In insurance contracts, there are contestability periods on life insurance contracts. There are also other conditions, including exclusions that may apply in those contracts to actually, which are important in terms of the adjudication of the claim. And just by virtue of the fact, without someone submitting a claim, or without some of the facts around the death, just the death in and of itself may not be sufficient for the company to know that it has a liability. So I know that that's a subtlety of insurance here, and the questioning seems to assume that just because the person's dead, automatically 100% of them result in a liability to the company. But I just want to make sure that that's understood.
I appreciate you sharing that. I'm just trying to reach a definitive point by which people have an understanding of the application to escheatment laws, yep. Your view of when the obligation is triggered, the extreme, right, and I'm not saying you follow this practice, is that in certain instances you would never have a triggering responsibility.
So right.
People exceed the mortality charts, you don't pick up fat tails, when should the state expect that money, and the property owners expect that money?
So there are circumstances where we will never be provided with proof of death or sufficient information to make a decision on there being a claim. In those circumstances, those policies would remain active, and depending on the type of policy, would remain active until such time as they would endow or superannuate, and the funds at that point would go through the unclaimed property process.
So you don't take into consideration...
And I should make one important point in terms of what I talked about earlier. To the extent that we are in a situation where we're in contact with the client and we've got bad addresses and we've got other things that we do that are aimed at kicking off investigations, including the use of death index, if any of those lead us down a path to believe that someone is dead, we will then take it on our behalf to do an investigation of that death. So in the example you described where an individual calls us and says so-and-so is dead, we write to them 3 times, they never respond. We look on RootsWeb, Accurate, we access SSDI. These are all examples of things we could do. We go to the state, we try to purchase a death certificate, and all of that ultimately results in us never getting sufficient proof that that person's dead. We are going to, for the purposes of that discussion, assume the person isn't dead. And we're not going to pay that claim or ultimately begin an escheat period.
And is the application of this interpretation consistent for all 50 states?
So what I would say is in all 50 states, it's our intent to comply with the laws in each of those states, and we do our best to do that. The actual application and process could vary based on what's required in any given state.
Along those lines, are there any states in which you use the date of death to calculate the dormancy period?
I do not know.
If you could follow up and provide a
Sure.
response. Does the company require a death certificate before its cheating policies match in connection with its 2007 comparison? Do you still do?
Generally speaking, we don't. So
Okay.
for the 2007 match,
2007 you did not, subsequent to and prior to.
so in the normal course of business, we require death certificates. There have been exceptions throughout our history where we thought there were extenuating circumstances where we've decided to waive that requirement. And I mentioned a few earlier, 9/11, the Massey Energy tragedy, the 2007 death match index run. And in those cases, we determined it was appropriate not to require death certificates and made that decision.
Prior to the 2007 comparison, if notice of the death of a policyholder insured by MetLife had been received, has MetLife allowed the insured's death benefits to go unpaid or unescheated if a beneficiary cannot be located and a death certificate has not been received?
So I think I answered that unless it's a slightly different twist. So in the example I gave before, if we have a situation where we are notified by phone, let's say, of someone's death, and we exhaust all the efforts that I described, including, the potential to write to the state to get a death certificate, and we can't get proof that there's a death, we wouldn't consider that a liability. And as such, because we wouldn't consider it a liability, we then wouldn't have any unclaimed funds to escheat because that policy would still be active.
Have you ever calculated the benefits provided based on death being the dormancy standard?
I'm sorry,
Yeah.
I don't understand the question.
Have you done different applications of your current interpretation of the application of escheatment versus the application of escheatment, understanding, applying the date of death standard?
I have never done any such calculation, and I don't have any personal knowledge of one.
Has the company ever done so?
Not aware. I mean, we again, there's different rules that apply in different states, and what we can testify to it is our intent to comply with those rules.
If you are able to locate the beneficiaries of these policies, do you pay interest on the benefits?
So in situations where we find the beneficiary, we would, and presume it's a good claim, we would pay the proceeds of the claim and pay any interest that's required by the given state based on how that varies in any given state. I believe in California, it's from 30 days past the date of death to the beneficiary.
And do you afford similar treatment in the escheatment for the escheatments to the state of California?
So is your question, do we calculate interest in the same way when we're escheating? We do not.
Okay.
So we can.
Can you explain?
Yeah, that is our interpretation of the applicable law.
Okay. And is and how long has that been the determination of the company, and can you provide me the basis for it?
I don't know how long it's been, and I can't provide the basis for an interpretation of a law. I'm not a lawyer to do that.
Right, and I would just say that the witness has been asked to testify as to facts and the construction of law, and they're testifying that they believe our current practices are consistent with state law as we understand it. But what would be the application if the law were different is something that they have not been prepared to testify to.
I appreciate that. Thank you. How much have you escheated as a result of the 2007 one-time death master match to the state of California?
Take that.
I would just give an estimate.
Sure.
Well, you can go ahead.
So the death match that was done in 2007 had a dormancy date in 2007. We reported to California in April. The amount was approximately $9.4 million in total. And we estimate that about $3.5 million of that was directly as a result of the match itself.
So we should be very clear. The $9 million is the full amount of unclaimed property that we presented, and as Mr. Cassandra testified, approximately $3.5 million. We would attest to this match.
3 to 3.5 million. Is that what you
Yeah,
said? Is
yeah,
that-
I'm saying
okay.
9.4 was the total we reported in our April report to California.
And just further clarification, that's what we reported. Obviously, you're very familiar with the process. Ultimately, that money hasn't been escheated yet. It'll be escheated as we go through the process and get to a final number at year end.
Yeah, we had some uncertainty here because we didn't see the numbers vary significantly over the prior years. And so obviously, they had a question as to the application and what was happening within the escheatment process.
I think you noticed that the April 2011 number was higher, and that we're attributing to generally attributing to the results of the 2007 match.
Okay. Can you comment on the demutualization process, what transpired there? Because I'm trying to apply application of what happened to the during the demutualization process, and then what took place, in fact, with the life policies.
So we can do our best to give you some information and speak generally. None of us that are witnesses were heavily involved in the demutualization process, but we'll do our best to do that. So when an insurance company demutualizes, essentially they go, and by the way, if I'm covering it at the wrong level, just interrupt me. We go from a mutual company to a stock company, and as a result, upon demutualization, we give the full value of the company surplus to our policyholders, which we did as per the demutualization documents in 2000. So at that time, we did a significant amount of work prior to demutualization in an effort to locate lost policyholders and clean up addresses, which we did, and ultimately resulted in payments of about 10 shares minimum per policyholder, or cash. Some of that went to the policyholders, and when those policyholders couldn't be located, some of those were escheated to the state. And again, I'm speaking at a very high level, but that's the general gist. I'm not sure where you want me to go with that.
And so my concern is about the value of the lost policyholders. Can you attach a figure to it?
For the purposes of escheating the stock, or for the purposes of their life insurance?
Both.
Okay. I can. So if your question is how much was escheated as a result of lost policyholders, we can certainly follow up with you. I do know back at that time there was significant dialogue between us and the state, and a fair amount of documentation, but I don't have that in front of me.
And do you have a sense of how much has been paid out to the policyholders and the state of California, and what the difference is, and then how you're going to proceed forward on this particular issue?
Can you repeat the question? I'm sorry.
Sure. How much has been paid out to the beneficiaries? What has been escheated to the state of California? Because obviously it's an obligation, and then the company's thinking as we go forward to resolve this situation.
Yeah. So I can't answer that question directly because we don't track it in that way, but what I can share with you is if you think about the block of lost policyholders, we put forth significant efforts to try to find them and found many of them, and as such have been in contact with them and receive claims from them, every day. Well, I shouldn't say every day, regularly. The vast majority of lost policyholders sit in what we've been calling our industrial block. And as it relates to those blocks, while we don't have regular contact with those individuals, we don't have an indication that those individuals have died, nor do we have a liability for death claims for those individuals. What we did find when we ran the match in 2007, out of that there was a fair amount of older claims, and those older claims have been paid or escheated, as I explained. But in the context of lost policyholders, we have those on our books, and one of two things will happen. Either a beneficiary will come forward, and when they do, a claim will be paid. Just one of three things. We'll find them in a subsequent match when they get added to the death index. Or, if neither of those happen, when those policies reach the superannuation date at the end of the table, because they are all in paid-up status in that industrial block, they will go through the unclaimed property system at that point in time.
Okay, thank you.
Thank you, George. I just have a few follow-up questions on the demutualization. What's the total number of lost policyholders that the company believed it didn't have a way to communicate with at the time it demutualized in 2007?
I'm going to see if I have that in my notes. I may not. Yeah, so we do not have that information handy right now. We certainly can. Oh, wait, I'm sorry. I apologize. So we had 1.1 million policyholders at demutualization, 800,000 of which were holders of industrial life policies. So the 1.1 million, approximately, lost policyholders. About 800 of them had industrial life policies where we were no longer collecting premium.
And under the terms of the New York Superintendent's order with regard to your demutualization, what were your obligations vis-a-vis the 1.1 million lost policyholders?
I can't testify to that.
Can you describe generally what the company did pursuant to its demutualization activities to try to find these 1.1 million lost policyholders?
Sure. So there were two primary efforts that preceded demutualization that were fairly significant. The family reunion program that we described, which we believe enabled us to get back in contact with about 500,000 policyholders, plus the work we did around our addresses on our database, which also we believe was quite effective in finding policyholders that were lost.
And of those, the 500,000 that you just testified to that you found through the family reunion program, were those 500,000 policyholders all policyholders who were part of the 1.1 million total lost policyholders, or does the 500,000 represent several other classes of policyholders?
I don't know exactly. My understanding, and I'll ask my team to help me here, is that the 1.1 was the amount that were lost at the point of demutualization. So as such, the 500 would have been found and hence be an amount above that. Is that accurate?
Right. So the family reunion program happened before the demutualization, and those policyholders were those 500,000 that we quoted earlier were found at the time of were considered found at the time of demutualization. So the 1.1 million does not include the.
Can you talk directly to the mic?
The 1.1 million we just talked about does not include the 500,000.
Okay, and then with regard to the second way in which you tried to find people using addresses, I take it that also occurred before the completion of demutualization, such that any of those, such that the 1.1 million total lost policyholders represents those policyholders that you could not find after you utilized family reunion and after you utilized the address search activity?
That is correct. What I would suggest we do here is we have fairly exhaustive documentation around our demutualization, some of which we have here, some of which we may not, that we would be happy to share. I think it's a topic that is fairly complex, and certainly we can continue to attempt to testify to it, but this is one that may be better suited through documents. And again, we have some of them here which we'd be happy to enter into the record.
Okay, well, we're happy to receive those. Do you want to provide those to us at this time then and describe what they are?
Sure, you want us to do it at the break and then I can give you the list?
That's fine too. How many documents are we talking about?
We have available to share with you correspondence with the state of Florida, correspondence with the state of New York, where we documented our efforts to find the lost policyholders. We have correspondence with the state of California, some of which relates to the same process. And we also have descriptions that we were provided inside of the order approving our order, provided by the state of New York approving our order of demutualization.
Okay, but all of these activities relate to activities of MetLife before or contemporaneous with demutualization. These aren't activities that were targeted at the 1.1 million lost policyholders after demutualization, were they?
Correct, they were not.
Okay, so we're happy to take those into the record at the break, but post-demutualization, you have 1.1 million lost policyholders. Is it fair to assume that some of these policyholders were dead?
So you're asking a hypothetical.
No, I'm just asking,
Yeah,
from the company's perspective,
it's
is it fair to
probably-
assume they were dead, some of them?
Yeah, it's probably reasonable to assume some were dead. What's tricky is it's not reasonable to assume specifically which were dead and when they died. So that's why we felt using things like the Death Master Index could help us do that, where Social Security numbers were in fact available.
So did you do that in 2000 then? Run Death Master against the 1.1 million policyholders that you had identified as lost policyholders?
We did not do that in 2001.
Did you do it in 2002?
We've explained that.
Well, it's a yes or no question. Did you do it in 2002?
Instruct the witness not to answer. I think I've indicated that there were usages of the Death Master Index prior to the systematic use in 2007 that were used, where the death index was used to ensure our compliance with the requirements of certain class action agreements, settlement agreements. I'll provide those agreements to you, and I'm glad to discuss with you on a confidential basis how we use the Death Master file to ensure our compliance with the obligations under those settlement agreements.
Okay, so putting aside our dispute about the whether or not you can testify about those agreements right now, was there any effort in 2002 outside of the litigation context to do a systemic sweep of the 1.1 million lost policyholders using Death Master?
Not that I'm aware of.
Was there any effort in 2003 outside of the litigation context to do a systemic sweep of the 1.1 million lost policyholders using Death Master?
Would it be okay if I made a clarifying point here?
Certainly.
A significant chunk of these don't have Social Security numbers.
That's fine, but
Just wanna make sure you're aware of
did
that.
you not in 2003 sweep those policyholders using Death Master outside of the litigation context?
Not that I'm aware of.
Okay. Was there any point in time when you did sweep the 1.1 million lost policyholders using the Death Master file, and when was that?
So to the extent that any of the policies had Social Security numbers, those were swept against the death index, other than that small assumed block that we talked about in that 2007 match.
Okay. And they haven't been swept since then?
Actually, they were swept this month, but that's the last time for individual life.
Okay. And then,
Mr. Commissioner, could I just
Go ahead.
make one clarification? So for the purposes of demutualization, we're talking about the policy owners. Under the plan of demutualization, the policy owner would have been the party who was eligible for demutualization proceeds. In many of the cases of the industrial block, the policy owner was not the insured under the contract. So if sort of the line of questioning is implying that with absolute certainty there was a death benefit payable under these quote-unquote lost policyholders. I don't think that blanket assumption is absolutely correct. So-
What percentage of the 1.1 million lost policyholders were, I'm sorry, what percentage of the 1.1 million lost policies were in a situation where the owner was different from the policyholder?
I don't know that. I don't have that statistic for you, but it's one fact in the context of those policies that should be considered.
Okay, but some number of the 1.1 million policies were policies where the owner and the policyholder was the same, correct?
That is possible.
Okay, and Deathmaster was not run outside of the litigation context against those policies until 2007.
To the best of my knowledge.
Other than that, we gave you a few other examples with some couple of states, but other than that,
Okay, and then was there any effort to do a manual check of the 1.1 million policy files against Deathmaster other than litigation? The 3 states you testified to in 2004 that you were engaged in some discussions with, and the 2007 sweep. Any manual checking of the 1.1 million policy files against Deathmaster?
not that I'm aware of.
All right. Then you testified a moment ago that with regard to the 2007 Deathmaster sweep, when you identified beneficiaries whose benefits needed to be paid, either because you had a 3-point match and through follow-up investigation you determined a benefit needed to be paid, or you had a more than 1-point match and through follow-up investigation you decided a benefit needed to be paid. In those circumstances where you determined that either a benefit needed to be paid or there needed to be a sheetment, you chose 2007 as the date from which you would run the date of death for purposes of calculating interest payments owed in either of those cases?
No.
Okay, can you clarify that?
Sure. For the purposes of claims to be paid to beneficiaries, we paid interest from 30 days past the date of death, as we believe in California, which we believe is consistent with the state requirement. In other states, we did what was consistent, we believe, for those given states. For funds to be escheated, we started the escheatment process for lost property in that 2007 date and did not apply death settlement interest, which is also our interpretation of how the law requires us to do it.
Even if through a 3-point Deathmaster match, there was an indication that the death occurred earlier than 2007, you chose 2007 as the date in which the dormancy period began to run for purposes of escheatment.
Right. So we would normally do it from the date we have a liability, and that liability happens when there's proof of death, which by nature of a 2007 match would be subsequent to 2007. We chose not to require death certificates and as such set that 2000 date as the date to begin the unclaimed property process.
Okay, so you understand why that answer may be less than satisfactory to the controller than I, because you've testified earlier that you had Deathmaster and were using it for certain portions of the business, principally annuities. It wasn't used for life insurance benefits in the individual context until 2007. So while I respect what you've said, or understand rather what you've said with regard to when you believe liability attaches for purposes of escheatment, is when you have knowledge. You didn't use a database that was available to you to have knowledge earlier. And so I guess what I find troubling is, given that history, why would you choose 2007 as the date of liability and not an earlier date?
Well, again, it's hard for me to testify exactly what the thinking was and why different options were chosen. I think the point I made earlier, which was our belief is that liability begins, or I should say the unclaimed property timing begins when liability is established. And while I recognize the fact that in some cases the date of death was earlier in the process, in fact, liability on these cases really wasn't established because there was no proof of death. And so we selected the 2007 date because that was the date that we, for the purposes of running the match, had been the first time we ran the match on that block of business and began the process. As an alternative, and I see your point, you're saying, well, why didn't you go back earlier than that? And our interpretation of our responsibility wouldn't have had us required to do that.
Have you done any analysis of what the interest savings is to MetLife by virtue of choosing 2007 as the date at which liability and the dormancy period runs versus choosing the actual date of death as reflected in Death Master on those policyholders for whom you made a match?
I don't know that information.
We've not made any such calculation, to my knowledge.
Okay.
I should also make just an important point. During that period, the dormancy period, we use that to the extent we can to search for beneficiaries. So I don't know if that's helpful or intuitive, but it's worth noting that in 2007, after we run that match, it wasn't as if, okay, let's just turn the money over. Our understanding of part of why we have a dormancy period is, as an insurance company, it gives us the opportunity to search out beneficiaries to see if we can find them, and then escheat only in situations where we can't. And we put pretty substantive efforts to make that happen.
Okay, let me see if either Minnesota or Florida have any questions at this point.
I just have a couple of questions. You mentioned that you have access to other databases and other methods of finding people. And we mentioned Accurate. Are there other systems that MetLife uses, for example, in its underwriting or in other departments to find information about its own customers?
About what type of customers?
Your customers.
So if your question is, do we use publicly available information in other ways throughout the organization? I'm certain we do.
Right. So for marketing and those kinds of things to try to target market products, there are all kinds of systems out there where you can look and see if you can identify a subset of customers to buy certain products, right?
That's not the area that I have responsibility for, so I can't comment to that, but that sounds logical, yeah.
You're aware of such systems, though, correct?
Can you give me an example of one that?
Well, I think there are a variety of them. Some of them are called predictive modeling types of systems. Some of them are called, just data mining systems. There are, I don't have trade names, but there are a variety of them.
Yeah, I should probably make a point. The majority of our business in the individual space is agent-driven. So it's, we do have a very small direct marketing arm of our business, but for the most part, our business is agent-driven. So I don't know if that helps.
So even on the annuity side, you wouldn't regularly use these systems, or you would?
Speaking for the individual annuity side, we would use the same kind of databases that Todd described that we use in other places of the company. We also do not have, in our case, we don't have a direct direct-to-the-consumer direct marketing business at all.
Yeah. So we do. So we do market. We use data and information. I want to be careful that if you're asking us to testify to a specific system or specific tools, we can't testify that because we're not aware of it. And we did also just want to share that we do have some direct in our organization. It's relatively small. The majority of what we do is face-to-face distribution on the retail side.
What I'm really getting at is, are there other systems besides just matching with the Death Master file directly where you could get information about your customers to try to narrow down this group of 1 million or so policyholders that you can't find because you don't have a Social Security number? I mean, there are a lot of different systems out there that give life insurance companies routinely information about their customers or prospective customers.
Yeah, so we talked about this a little bit in Florida too. I think the issue of lost policyholders isn't just a MetLife issue. It's an industry issue, and it cuts across multiple jurisdictions. And I think it is a place that's fertile ground for the industry to talk about with our regulators, ways to do that. our intent is whenever there is an individual that we can find out that they are dead, if you know, to get those monies in the hands of the beneficiary. So we certainly would be open to dialogue around best practices in that space.
Well, I think that in areas where the companies are marketing and in areas where it financially benefits, not to be crass, but financially benefits the companies, that there are a lot of systems and efforts available. You can find out a lot about your policyholders or prospective policyholders, and do. And if you can think in terms of next steps, applying those types of systems to this issue would make some sense. I mean, you know, before you write somebody what kind of prescriptions they've bought, you know an awful lot about that person.
You know, I think that's an area that we can and should have more discussions. You know, I probably should have made another point earlier in this context, because I think some of the hypothesis around all of this is that somehow MetLife's intention here is designed to make more money. And what we're doing here is we're using this data in one way on one side of the house and another way in the other. And the reason we're doing that is because we're looking to hold funds that we shouldn't hold and hurt policyholders. And I just want to make 2 points that I think are important on that. One is that couldn't be further from the truth. We're talking about a very large company, and we're talking about rather insignificant dollar amounts in the context of that. Keep in mind, we ran the death match in 07 in our life business, going back decades. And no, 80 million is not small, but found 80 million over decades. So we're talking about relatively small numbers. The other piece, which I think is important as it relates to the industrial life policies, those policies continue to perform. And what I mean by that is that we issue dividends to those policyholders every year. So as those policies stay on our books, they're growing. And one of the things in the PowerPoint was, do you have situations where policyholders pay in more premium than their face amount? And in the industrial block, since we made them paid up and we've been issuing dividends every year, those policies are growing and in some cases are double and triple the face amount of what they were at the time of issue. And ultimately, when a beneficiary comes forward, they'll be escheated at that full, they'll go to that beneficiary at that full value, or if they're escheated, they'll be escheated when they superannuate at that full value. And I want to make sure that's clear in the context of this dialogue.
For the 1.1 million policyholders that were lost, do you have any idea of approximate face amount at risk on those?
I don't have it handy. You may have it, Frank.
I don't have that handy, but these would tend to be very low face amount policies.
Did your actuaries or anyone internally then look at that and say, well, we can't find these policyholders, we've done some diligent search, we have some assumption that some of them aren't ever going to submit a claim, let's release some reserves, anything like that?
I think the documentation of that is covered in both the plan of demutualization and the documentation that Teresa said she was going to share at the end of the meeting. So I think if you look at those documents, you may see some information there.
Older blocks of business for individual annuities, you're doing the quarterly Death Master matches?
We're doing it monthly on our payout annuity business, and then we're doing it quarterly on a portion of our deferred annuity business.
Do they receive annual or quarterly policy statements?
Well, the owners that are in receipt of our payout annuities are getting typically a monthly check from us. The owners of the deferred contracts, the pay-in annuities, get a quarterly statement from us showing the value of their contract, which investments they have, and so on. They also get an annual prospectus from us, if it's a variable contract, showing what funds they're invested in, and then they frequently get a privacy notice annually from us as well.
So, notwithstanding Death Master, what does the company do when you stop, they start coming back, the policy statements and prospectuses?
Sure. So if any of those documents is returned to us as mail that can't be delivered, we would follow the process that we talked about earlier about trying to locate of that individual. And to the extent that we could not locate that individual, then we would follow our normal process that could ultimately lead us to an escheat situation.
What is the normal process? You can't locate the person or name beneficiaries. What is the process when you finally get to escheating the property?
My understanding is that we generally try to follow a process that would call for regular periodic follow-ups for at least a year, and to the extent that we can identify that individual at the end of that period, we would follow our normal escheatment processes.
We've been talking quite a bit about industrial policies, and my guess is that there are significant numbers of the public who have no clue what we're talking about. It's a term of art that's used in the industry. I'm wondering if you can give us some better understanding of what is an industrial policy. What are we talking about?
Sure. So industrial policies typically have a face amount of $1,000 or less, and typically the premiums were paid weekly or monthly, and typically the agent is the one collecting the premiums. MetLife stopped issuing industrial policies in 1964, around 1964.
And when these were paid on a weekly or monthly basis, how much would the policy owner typically be paying?
It's small. I don't know the number, but I don't know.
It was generally cents, nickels and dimes for the coverage.
And who were these policies typically sold to when they were sold?
I'm going to be careful because I don't want to answer definitively, but they were typically designed for, given the lower face amount, people who their life insurance needs would be for amounts of that level. So I would think of it in that way.
They were typically lower income individuals or households?
You know, I don't know that definitively, but intuitively I believe that's the case.
And, I mean, are you aware of any marketing materials that MetLife utilized prior to 1964 to sell these policies, and who were they being marketed to?
I'm not.
Okay. Any of the other witnesses have any understanding? I think you testified you've been with the company for some
37 years.
37 years, yeah. And just wondering if you have any understanding as to whom these policies were marketed when they were marketed.
I don't. I grew up on the employee benefit side of our business.
Okay.
I was born in 1964.
There you go. But generally, these were policies that were sold by agents. They were sold door to door in communities throughout this country. They were very low face value life insurance policies, about $1,000 or less, I think you testified to. And generally speaking, in the literature that's available with regard to these policies in the industry, these were policies that tended to be purchased by people of more modest means. Is that fair?
I think that's a reasonable summation, yeah.
Okay. And then,
And those were the policies, Commissioner, that the Family Reunion Program was actually targeted at. So you might recall this morning we testified about the Family Reunion Program, which was a metropolitan-specific effort to attempt to find all these owners. And we ran multiple media ads.
I recall that. I do recall that.
We spent about $20 million on that at that point in time.
And with regard to the $80 million in life insurance benefits that you paid out as a result of the 2007 Death Master sweep, what was the average benefit that was paid out within that $80 million?
We're going to do some math right now, and we're going to tell you. So we're going to take the 80 million and divide it by the 18,000 plus the 7.
So about $4,700.
Okay, on average.
If I just took the 84 million and divided by 18,000. Yeah.
All right. And
give or take some sense. Lucky I brought my calculator.
Okay. So about $4,700 on average
That's what it looks like. Yeah.
to 18,000 plus 700, right? It's 18,700 people that were paid out.
80.
Yeah.
Shall I do it again? 84 million. 18,700. 4491.
So we'll make sure that's entered in as an estimate. but that'll give you the order of magnitude.
So I'm just wondering, I mean, based on your knowledge of your policyholders, whether you can share with us what sort of impact there might be on a family or individual not to receive, say, a payout of $4,700, as in the context where a parent or grandparent or some other family member has passed away and had a life insurance policy with you.
I think that impact is going to depend on the person. I mean, it's hard to make a general statement on that. I think in any situation when someone buys life insurance, they've bought it for a reason, and our intent is to pay out all amounts that are due, and the presumption is that those individuals bought it to serve whatever purpose they served, and I think it's a personal situation.
So it's a real benefit when they get paid then.
Yeah, I think so. That's sure.
I mean, it makes a difference in their life. That's why they purchased the policy.
Yeah, I think if well, keep going. I'm not sure where you're
No,
going.
go ahead. Well, I'm just, yes or no. I mean, they buy the policy for a
I think
reason.
it depends on the person, right? You'll have some individuals who may be more well off, and the payment of life insurance may, relative to their net worth, be relatively small. And for others, may be less well off, and it may be relatively large. It's going to depend on the person.
Okay, but the owner of the policy, or the insured individual and the owner, if they're coterminous, bought that policy with an idea in mind of helping a beneficiary when they passed away, correct?
It's reasonable, yeah.
I mean, that's the deal. That's why they come to your company.
Sure.
Okay, so I guess what I'm struggling with is your characterization of the importance of the $84 million that you did pay out as a result of the Death Master sweep in 2007 as substantially or relatively small dollars. And I'm struggling with that because I think that people buy this, people get this insurance because they believe it confers a real benefit to their beneficiaries. And from where I sit, $84 million is a substantial sum, and $4,400 is a substantial sum.
We agree. I mean, for any individual that got paid those proceeds, for that individual, that's a big deal. And that's why we think using the death index on a regular basis as a safety net to supplement the core process. Because over that period where we found $80 million through the death index, we also paid $44 billion through the normal channels. So the normal channel process works. We found $80 million, and if anybody was one of those 18,000 people who got that $80 million, for that person, that's real important. And that's why we believe it makes sense to use that safety net process on a prospective basis so that when the core process happens to not work, there's a way to support that.
And I think that's where you and I have a disagreement. I think that rather than using it as a safety net, it should be an integral part of the company's effort to try to make sure that beneficiaries get paid, not a afterthought. Those are my words, of course. But now, as to...
Could I comment on that?
Absolutely.
Because I think that would be a great topic for discussion between regulators and the industry, because this is the type of thing, and we're perfectly comfortable talking about it in a public forum, in a hearing, but this industry and the NAIC over the years have enacted substantive change that helps our customers. That's what we're here to do. So we would welcome engaging in a dialogue to determine a best practice across the industry. And if this effort leads to that dialogue and we get to a place that we all feel good, that's what everybody's trying to do here.
So you've testified to the company's new policy as of 2010, and I think you've testified as well in April of this year you did another Death Master sweep against individual life insurance policies. Is that correct?
It was in June, not in April, but.
I was in June of...
In May, right? Individual?
I'm sorry, we're still in May, yes. It was
Right.
in May. We intend to finish by the end of June.
Oh, well, maybe we better clarify that. So let's go back to 2010. Since 2010, can you describe again the uses to which you've put the Death Master file?
We took the decision that we were going to begin use of the Death Master file no less frequently than annually in the businesses where we had the records. We began that process in late 2010 and began with the first product that we matched under the new process were our retained asset accounts. The second product in the list was our individual business, which we have individual life business, which we are doing live in May.
Okay, that's the part I didn't understand. You're in the midst of doing the individual life business now.
In fact, the raw match, I'm informed that the raw match has actually been run, and now we're beginning the investigatory phase.
Okay, and can you explain, will you be using the same protocols that you used in the 2007 sweep for this most recent sweep of the individual life insurance policies?
I would say generally, yes. I cannot say with absolute 100% certainty every protocol is the same, but the logic and the intent, which is to find every policy and every policy that the insured has died, that is our intent.
But you'll start with an effort to look for a 3-point match, and then you'll do a 1-point and greater match, as you testified to earlier, you did in 2007?
I believe that to be the case.
Okay.
I can't say with absolute certainty, but the first sweep is to be the 3-point match, yes.
All right. And then what will you do after that?
We will start the investigatory phase to determine if those 3-point match hits are actually insured, and then to begin to find the beneficiary.
Okay. And then is it your intention to do an additional sweep using 1-point or greater matches?
I don't know that we've taken that decision yet, Commissioner.
All right. And then what other product lines do you plan to apply Death Master to based on this new 2010 policy? You said retained asset accounts, individual policies. What comes next after that?
Then the group life insurance business where we are the record keeper.
Okay. Just where you are the record keeper. All right. And you're continuing to use it on a monthly or quarterly basis on the annuity product based on whether it's paid in or a payout status. Is that correct?
Yes, and as I mentioned earlier, the block of the deferred business that we were not currently running against, we're adding that as a result of this plan as well beginning this year.
Okay. Remind me again, which block of deferred business was that?
I made a distinction earlier today between our older business and our newer generation business. It's about 50-50 on the deferred side that we aren't doing, that we will add this year.
Okay. Now, I want to turn our attention to the retained asset accounts because we've had some testimony about that. And you've indicated you did a Death Master sweep in 2010. Well, you did a Death Master sweep, I guess, late 2010, earlier this year against retained asset accounts. Can you, just first by describing how you use retained asset accounts, what they are?
Sure, and I'll also clarify we had done a sweep prior to that in 2006, which I can talk to also. But retained asset accounts are a life settlement option available in most policies. They are aimed to enable the policyholder or beneficiary to have funds put into a retained asset account, to enable them to have time to decide what to do with those funds. Retained asset accounts offer interest rates that are pegged to be above at least one of 2 market indices. I can give you what those indices are, I just don't have them off the top of my head. And they have a minimum interest rate. That minimum interest rate varies anywhere from 3% to 0.5%. They are insurance contracts that are supplemental contracts. And feedback from our customers is extremely positive on our retained asset accounts. One of the stats that I think it's worthwhile to share with you is about half of our retained asset accounts today are earning an interest rate of 3%. And in today's environment, we think that's quite competitive. So let me stop there. That's probably a general answer.
Does MetLife refer to these as total control accounts
That
also?
that is our product, our total control account.
But that's synonymous with retained asset account, is that term is
Correct.
generally
Think
used in
about
the
it as
industry?
our version of the retained asset account.
Okay, and you mentioned that it's a life settlement option. For which of your products is a retained asset account or total control account and a life settlement option?
I believe, and I'll ask Mr. Cassandra to help me, it's for group and individual life.
That's correct.
Is there anything else?
Yes, that's correct.
All right. And with regard to that option, is it an opt-in option or an opt-out option?
So the optionality would depend on the type of contract that's in place. For individual life insurance, the policyholder will have the option to elect a settlement option, typically either a retained asset account or total control account or a check. Policyholder usually doesn't make an election. If they don't make an election, then the beneficiary will have the option to make an election. If the beneficiary doesn't make an election, then the default will be the total control account.
Okay, and is that
I should make one other point about what the total control account is. It's an account that's interest-bearing, but it's also check writing. So the individual, once they have the account open, they want to write one check to themselves, they can close it, immediately. So and in fact, a significant amount of our accounts close relatively quickly.
So if I understand correctly, first, the policyholder is given the election. So they're given the option to decide whether or not a retained asset account will be utilized in the event of their death and the payment of benefits.
Right, and we're talking about individual here. The individual policyholder would have the first option.
And then if they don't make an election, then the beneficiary can make an election. When does the beneficiary make the election?
When they fill out the claim form. And I should note, what I'm articulating is a general statement. There are some state laws that govern how this works, so in certain jurisdictions it may work a little differently.
So does the policyholder at the time that they purchase the policy have to affirmatively elect in some way the total control account?
They may, or they may not. They don't have to make an election.
They don't have to make an election?
And in fact, most do not.
Okay. So then it defaults to the beneficiary. And so on your claim form, generally, how is that manifested? Is it a box that has to be checked or unchecked? Can you explain that for us?
It's some indication. I'm not sure if it's a box or if they write it in, and we certainly would be happy to provide you with copies of the forms to give you more details on that. But we do ask them to make an affirmative election.
So if they don't somehow affirmatively ask for the total control account, then and the policyholder hasn't asked for it, then it defaults to the total control account.
Correct. And our thought process there is, in just about every circumstance that we can think of, the total control account provides more benefit to the individual than the check. And once they get a check, they're precluded from opening the total control account. It's done. So if we send them a check, they've now lost that option. So we send them the total control account, and we clearly articulate to them, this is an account, you can write one check and take all your money out, immediately if you wish to do so.
So what percentage of the individual life insurance policies have either the policyholder, let's start with the policyholder, what percentage of those in which benefits have not been paid have the policyholders elected the total control account?
And I had all these answers in the fall.
Is it a small percentage, though?
What percent elect the total control account?
Yeah,
I don't know.
Okay.
We can follow up with you on
but
that.
I think you said most don't.
Policyholders, it's a very small percent
That
make an election at all.
make any election.
Correct.
All right. And then do you have any estimate of the percentage of beneficiaries that make an election one way or the other?
I don't.
Okay. What of the life insurance policies in which benefits have been, well, let me ask this question a different way. Of the total, what number of total control accounts do you have open currently in the individual side?
Could have given you the total. Do we have it in our documents?
I do not have the breakdown.
We may have it for you in a second. Yeah, so I have it in aggregate. I don't have it broken down between group and individual. It's approximately 500,000 accounts in aggregate with a total of about 12 billion in assets.
Now, you mentioned the interest that's paid on these accounts. Does the company earn more interest on this money that's held in these accounts than the beneficiaries who now own these accounts earn?
So we pay out interest on the account consistent with the contract. And that interest has varied over the years. It's been much higher than it is. Right now it's a very low interest rate environment. The company holds the funds in our general account, and our general account earnings vary based on the risk and duration of any given product. So we certainly do aim to earn more than we credit, but I would suggest to you, if you look at the environment right now, a 3% rate is fairly compelling.
But if you earn more on the aggregate dollars that are held in total control accounts, if you earn more than the interest rate available to the beneficiaries in those accounts, you don't pass those additional earnings directly on to the beneficiaries, correct?
No, we pay out the beneficiaries, the account holders, consistent with our obligations, consistent with the customer agreement, and consistent with the way we're supposed to do it. We take risk on our total control accounts. We provide guarantees, and we invest the money. And even though these aren't bank accounts, because they're not, I would think about it in the context of financial accounts more generally.
Okay, fair enough. But the question was, if you earn more by investing the aggregate dollars in the total control accounts than what you have contracted to provide those account beneficiaries by way of interest, you don't pass through to them the additional earnings that you make on their money.
Right. If we make more, we don't pass that through, and if we make less, we don't ask them to pay us less.
Have you ever made less on their money?
So we have guarantees out there in today's environment where the rates are pretty good. I don't have the data in front of me, but I believe there are some quarters, especially at the height of the financial crisis, where the financials on this business wasn't particularly favorable. And so
But you made less than the contracted interest amount on those accounts? Because I'd imagine those interests, as you said, they're pegged to indices that themselves fluctuate based on what's happening overall in the financial markets. So you actually earned less than the interest that was paid to them?
yeah,
If you know.
No, we have guarantees here. So I mean, if you take, I'm going to give you a hypothetical because I don't want to testify to something I'm not sure to.
Let's not do a hypothetical. I mean, if you know,
Okay.
if you don't know, you don't know. I mean, that's fine too. But
Yeah, I mean, I don't know
That's fair.
definitively.
all right, then I guess with regard to the total control accounts, do you have any practices or procedures for determining when those accounts have gone dormant?
So our procedures around total control account, we contact our policyholders regularly. We send them statements at least once a quarter and once a month if there's activity in the account. We send them an annual 1099 for the interest earned. If we have 3 instances of returned mail, we will then assume that that account is lost in some way, and we'll begin a procedure to search for the owner, and if ultimately we can't find the owner, begin our unclaimed property process system. In many cases,
I'm sorry, go ahead.
no, in many cases, we may find that the individual is deceased, and if we do, then the beneficiary, if one is named, the proceeds would move to that beneficiary. We also, as I mentioned earlier, have deployed the Social Security death match twice thus far for retained asset accounts, for our total control account. We did it first in 2006 and again in 2010, and that's certainly another way to search for people who may have died.
What's the search procedure you use when mail has been returned 3 times?
I can't testify exactly to what that is. Certainly our intent is, for example, if there is a beneficiary, to try to find that beneficiary. But if that search criteria fails, that account would go through the unclaimed property system then.
Okay, but
And I don't know the exact procedure, I
I'd
apologize.
be interested in knowing that if there is a document or some additional testimony, we can get at a later time on that. Once it goes to unclaimed property, what does that mean and what happens then?
Sure, so then we would follow the unclaimed property rules of the given state that would apply for the purposes of determining escheatment. So I guess that's really the answer.
Okay, and when the mail has been returned 3 times and you begin the search procedure, does the search procedure include the utilization of the death master file to try to make a determination whether the beneficiary who has a total control account has passed away?
Yeah, so unfortunately, that's the question you'd asked before. I don't have the specific details on exactly what we look at for RAAs in that. I do know the steps subsequent, the mail, and following it, the unclaimed property. I'm not as clear on exactly what those search steps are in the middle.
I believe we write out letters to the account holder and to the beneficiary.
Say again? I'm sorry.
Write letters to the account, to the last known address or to the address of the beneficiary if we have one listed on the file.
That's part of the search procedure.
That's what I believe that to be, yeah.
All
But we
right.
can follow up with you on it.
Okay, and then are there, other than the return of mail 3 times, are there any other triggers with regard to the initiation of the search procedure? Or is the return of mail 3 times the only trigger?
So the only thing that's new and emerging, and this is relatively new out of the discussions last fall around retained accounts, asset accounts, we did a fair amount of work both with NCOIL and AIC in the context of a bulletin and then NCOIL's model law. We believe that will ultimately result in certain states requiring a certain period of dormancy and a clear definition of dormancy, which we clearly would intend to comply with.
But right now, you don't start the dormancy clock running until you've concluded the search procedure and decided that you can't find the person?
Either through the return mail process or through the death match process, which we talked about, earlier.
Okay, and of the 500,000 total control accounts that you have, how many are now considered in the dormancy period?
So how many have been moved into the unclaimed
Yes.
property system?
Right, I'm sorry.
Yeah. I don't know that number. I can give you some data on the 06 match, which might help you. Do we have? We may have that. I apologize.
Okay.
It appears that this would say the total number of TCA in our unclaimed fund system is about 38,000.
Do you have a figure for California?
I'm sorry, I don't have that detail.
Okay. And
We're
then,
just going to check. We may have it.
All right.
Just give us 1 second.
so while you're checking,
That's only what will be escheated this year, yeah. We reported 776 items for California that will escheat in December of this year.
all right, that's the number that you believe have
Different question.
gone through the
Not
dormancy,
quite
so a
the-
different question.
Yeah, not quite the question you
I
asked.
understand. Okay, but you've reported 776 as cheating in your most recent report to the Controller's Office?
Yes.
All right. Then, can you share with us what you did in 2006 vis-à-vis the Death Master file and how you used it in relation to the total control counts?
Yeah, so it's similar to what we talked about in life insurance in 2007. We ran it against the population of active total control accounts. We identified about 1,300 accounts where there were matches, went through a process to investigate those matches. Many of those accounts were closed. Some of those accounts resulted in beneficiaries being located and funds either being paid or transferred to the beneficiary, and some of those resulted in beneficiaries not being located and escheatment to the states.
And what was the trigger point for deciding that you had a Death Master file match in 2006 with regard to the total control accounts?
Yeah, I don't know the answer to that.
I'm sorry, could you define trigger point?
Well, by that I
Why
mean,
didn't we do it in
you
06?
talked earlier about using 3 points and in some
Oh,
cases
okay.
using the 1 point or
Yeah,
more.
okay.
What was the what was the
In
protocol
two- in
used in the
2000
application of the Death Master
In
file?
2006,
Yes.
I believe it was just the Social Security number as the match. That triggered the investigation.
Regardless of any other data field match, if you had a
Right.
match on Social Security, that
We
triggered?
worked it up.
And if you think about that, the context of TCAs, we would have, by definition, we should have social on all those accounts.
Because of the tax reporting requirements under the TCA.
Why didn't you require matches on the other fields as you did on, as you've been doing on the individual life insurance side?
I don't know. I was not involved in the definition of the 2006 criteria.
Mr. Katz, do you know?
Why in '06 did we only use the 1-point match?
Right.
For TCA, we would have had SS for all of those because generally we're sending out 1099. So if we had an account open, which, and keep in mind, this account would typically have been a beneficiary of a life insurance claim that would have provided with us with a social when that claim was filed. We felt that the records on that were pretty good, and that would, in and of itself, create fairly good match criteria.
Right, so with regard to those 1,300 accounts for which you had a positive match with the Death Master file, do you have a breakout with regard to, number that were sheeted, number in which those amounts in the total control account were paid to some other downstream beneficiary, and anything else you might have done with the money?
I think the stats we can share with you, but I think they're national. They're not California.
That's fine.
If that's okay. Yeah.
So of the 12, roughly 1,300, 791 of them were closed. 362 were closed before the match. 274 paid to a beneficiary, heir, estate, or trust. 155 sent to the unclaimed fund system. 155 sent to the unclaimed fund system.
So I got lost somewhere. There were 1,300 matches. You said 791 were closed?
Right.
So of the 1,300, a total of
Correct.
791 were closed. And then 362,
We're breaking down the 791 is what
already.
Mr. Sanders
And
doing.
what does the 362 represent?
Closed by the account holder, there was no balance in it.
So we found a match, but there was no money in the account.
Okay. And then 274 were paid to other beneficiaries,
Beneficiary or other heir.
and then 155 were moved into unclaimed property.
Right.
Okay. And then you said that you ran it again in 2010. Can you describe how you used the Death Master file with regard to the total control accounts in 2010?
I don't know if you have that handy, but is your question, was it a 1-point match, or is that a?
Yeah, I'm just generally interested in what you did. Was it just the same process that you did in 2006, or did you do something different?
We did both. So where we had a Social Security number and a date of birth, we had 4,800 accounts.
And then Social Security alone?
2,900.
All right. And then
And
what?
that process was done really toward the end of the year in 2010. I don't know if we have, I don't have stats here for the breakout of that, so those are still being worked as we speak.
And just one point I would make, two-thirds of those, based on the date of death on the file, two-thirds of those has happened within the last year, to the best of our knowledge, so they were very recent. So that goes to the point about, if you're matching in real time, most of these accounts generally would resolve themselves by the beneficiary coming forward and claiming the benefits without doing the match.
So with regard to the total control accounts that you paid out as a result of the 2006 or 2010 sweep, did you require a death certificate before you paid out those accounts to a beneficiary of the beneficiary, so to speak, or an heir?
I'm sorry, I don't know that level of detail. I don't know.
Do you know what, if anything, was required before you closed the account and made a payment to another beneficiary or heir?
It's just an assumption, because I don't have actual knowledge of what those extra detailed steps that went after the match. I'm sorry, I just don't have that knowledge.
Okay, and with regard to those accounts that you moved into unclaimed property status based on the 2006 or 2010 sweep, what was the triggering determination that caused you to conclude to move them into unclaimed property status?
I believe it was that we could not find the beneficiary after trying to communicate via letter.
So you had a match on Death Master, couldn't find him, decided to move it into unclaimed property.
We tried to find the appropriate beneficiary, couldn't find the appropriate beneficiary, and then moved into unclaimed property.
Okay, great. I want to see if the controller has any follow-up questions on retained asset accounts.
Just along the lines of the questioning earlier about the, I'm not quite clear about the financing vehicles when the commissioner was asking about the differential, whether if there were, in the event of earnings surplus versus actual payments, the use of, do you have separate financing vehicles for these particular accounts? Right, I mean, it's an area of active interest in the financial community for private equity.
The TCAs are part of the general account of MetLife.
Okay, thank you.
We're going to take a break, but before we do, let me just see if Florida or Minnesota have any questions about the retained asset accounts.
What, since they're in the general account and investments, what was the first quarter of this year, what was the investment yield on your portfolio?
I don't have that level of detail. I'm sorry, Commissioner.
But basically what you're saying is you make the spread difference between what you pay out and that investment yield on your general portfolio?
Yes, and if the earned rate was lower, obviously.
Great. And so I think at this point, if the Insurance Department's General Counsel can talk to the counsel for MetLife about the additional documents that we're going to put in the record, this would be a great time for that conversation to occur. Let's take a 15-minute break. Thank you.